Good evening, everyone. Welcome to Law 2220, Real Property 2. Today, we are covering Worksheet 1 on easements. I am your lecturer for this course, Miss Grace Bhagwandeen, from the Faculty of Law, University of the West Indies. Easements is really one of the most practical areas of property law that you will encounter. So, let's dive straight in. The objectives for this topic. By the end of this topic, you should be able to understand, firstly, the essential features of an easement. Secondly, analyze different types of easements. And thirdly, evaluate how easements are created and how they operate. Now, what is an easement? Well, it is a right over someone else's land, what we call in alieno solo. So, think of a right across your neighbor's property. That can be considered an easement. Now, for a right to qualify as an easement, it must satisfy 5 essential requirements. Let us now analyze these features. First, there must be a dominant and servient tenement. So you can't have an easement in gross, meaning you can't have an easement that just benefits you personally. It must benefit a piece of land. The land that benefits is the dominant tenement, and the land that is burdened is a servient tenement. So the cases on point are London and Blenheim Estates Limited versus Ladbroke Retail Parks and Keefe versus Armour. Secondly, the easement must accommodate the dominant tenement. This means it must benefit the land, not just provide you with a personal advantage. Hill versus Topper is your classic case here. A man claimed an exclusive right to put pleasure boats on a canal. The court said no, that's a business advantage, not a benefit to the land. Now contrast that with Moody versus Staggles, where a right to hang a pub sign on neighboring property was an easement because the pub operated from the dominant land. Thirdly, the dominant and servient owners must be different persons. You can't have an easement over your own land. I mean, think about it. Now, Kilgore versus Gads establishes this. Fourth, the right must be capable of forming the subject matter of a grant. Now, this has 3 sub-requirements. The right must be sufficiently defined and not too vague, like a right to air, where this was established in Webb versus Bird, and it was not considered to be an easement. Fifthly, the right must not substantially deprive the servient owner of possession of the servient tenement. Copeland versus Greenhalgh is your leading case, where a wheelwright claimed the right to store unlimited vehicles for repairs, and the court said that is virtually claiming possession, and it was not an easement, and there must be a capable grantor and grantee. Now, an easement must not require the servient owner to spend money. Liverpool CC versus Irwin confirms this. Note also that an easement can be legal or equitable. Walsh versus Lonsdale is your authority for this. Now let's talk about how easements are created. There are several methods. First, express grant. This is the simplest and clearest method. The owner of the servient tenement explicitly grants an easement to the dominant tenement owner, usually by deed. No special form of words are required, provided that the extent of the easement is reasonably clear. Secondly, express reservation. Now, this is the mirror image of an express grant. It arises when the owner of land sells part and retains the rest, and he wishes to reserve an easement over the land sold in favor of the land retained. Now, at common law, A vendor could not directly reserve easements for the land that he was selling. He could only do so indirectly by getting the purchaser to re-grant the easement back to him. But now statute has made that re-grant unnecessary. So we have Section 69 of Barbados, Section 65(1) of the UK Property Act, that now provides that a reservation can be operated by law without any need for a re-grant. Then we have implied grants. This is where it gets interesting. There are 3 categories: easements of necessity, intended easements, and easements in the rule in Wealden versus Burroughs. Easements of necessity. So where land is landlocked and access is absolutely essential. The leading case is Lush versus Dupree, and the key word used was necessity, not convenience. Nickerson versus Barclough and MRA Engineering confirmed that the test is strict. In Wong versus Beaumont Property Trust, it extended this principle, where a restaurant needed a ventilation duct to comply with health regulations, and the court in this case did imply an easement of necessity. Intended easements. These are implied to give effect to the parties' common intention. Pullback Colliery versus Woodman gives us that test. GNO Operators versus Kingston is your Jamaican authority. What about the rule of Wealden versus Burroughs? So when you own 2 plots and sell one, any continuous and apparent quasi-easements that were necessary for reasonable enjoyment of that land and in use at the time of the grant will pass automatically. What about acquisition under statutory provisions? Well, this is massive in practice. Section 16 of Chapter 5601 of the Conveyancing and Law of Property Act of Trinidad and Tobago provides that a conveyance automatically includes all ways, easements, rights, advantages whatsoever pertinent to the land. What is the significance of statute? Well, the cases show that this converts even mere licenses into easements. What about prescription? Long use can ripen into an easement. Dalton versus Angus explains this theory. Basically, we presume that there was originally a lawful grant that has been lost. There are 3 requirements. The user must be as of right, not by force, not secretly, not by permission. There are 3 methods of prescription. The common law prescription, which states that 20 years creates a presumption of use since 1189. Secondly, the doctrine of the lost modern grant. The case of Tahiti Minerals versus Norman stated that 20 years creates a legal fiction that a grant was made and lost. But the Prescription Act stated that 20 or 40 years can be satisfied under statutory provisions, and Hart versus Pierce from the West Indies applies these. So how do easements end? There are 3 ways. Unity of possession and ownership of the dominant and servient tenements. Basically, the cases state that if the same person owns and occupies both tenements, the easement is extinguished. By express release by deed, this was stated in Waterloo versus Bacon, where the servient owner expressly released it in equity. Thirdly, by implied release or abandonment. Ecclesiastical commissioners stated that non-use alone isn't enough. 20 years may raise a presumption, but you need evidence of that intention to abandon. So, to summarize, easements must have 5 essential features. They are created by express grant, implied grant, statute, or prescription. Easements can be extinguished by unity, release, or abandonment. These are your additional resources to refer to. So, if you have any questions at this time, feel free to ask me. And remember, this is my contact information, grace.bagwandeen@uwe.edu. Feel free to reach out to me with any questions. Thank you and have a great evening.